Do you care about men and women receiving equal treatment in society? Most of us do, and if so, then you probably would have supported the passage of Title IX in 1972. Title IX states simply, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." Yet, Title IX became a vehicle for discrimination. How? The same way most government growth occurs, through the administrative state. On top of that one sentence, unelected bureaucrats added hundreds of pages in government guidance on how the law should be followed. Despite no mention of sports in the law, it was applied to high school and college athletics. And despite the fact that men's sports have historically been and remain more popular, the Federal Office for Civil Rights suggested in its guidance on how schools must obey Title IX that the number of male and female athletes should be substantially proportionate to their respective enrollments. While female participation in athletics has risen substantially since the passage of Title IX, and that is the law's most cited success, female participation is not and will never near that of male participation. Between 1981 and 1999, this guidance led to 363 men's sports teams being cut from university athletic departments to try to create proportionality. The original text also did not cover sex crimes, but in 2011, the Obama Education Department issued a letter to academic institutions telling them to use a preponderance of evidence standard of proof in sexual assault cases. Under the department's view, higher standards of proof would allow women to be subject to discrimination, and thus in violation of the law. That would lead the government to revoke a school's federal funding, bankrupting the school. A preponderance of evidence standard means that the likelihood a crime occurred is just over 50%. As cries of "believe the victim" show, even when there's nothing to further the claim, to many feminists, an accusation alone suffices. At Amherst College, a male student was expelled after being accused of sexual assault, despite evidence later showing that it was actually the accuser who sexually assaulted him. Activist academics and administrators interpreting government guidance can take things even further. At the University of Tennessee, a student who didn't know his TA's name but needed to put it on his quiz made one up. Unbeknownst to him, the common name he picked, Sarah Jackson, also happened to be that of a porn star. His professor gave him a 0 on the quiz, and he was informed that putting that name down met the Title IX definition of sexual harassment, forcing the university to investigate him. In 2016, the Obama administration interpreted the law even further, instructing institutions that the law not only covered a person's biological sex, but also their gender identity. Institutions must use transgender students' pronouns of choice and allow transgender students to use the bathroom and locker rooms of their choice. In 1972, none of the lawmakers voting on Title IX could have ever predicted it would apply so broadly. Though rolled back substantially by the Trump administration, Title IX's growth proves, if you give someone an inch, they will take a mile. One sentence of law that looks agreeable to most fair-minded people was expanded to create hundreds of pages of guidance, contorting it into something the people's elected legislators in 1972 could never have imagined. Title IX shows that when interpreting laws, to look at anything but the original understanding allows the power of government to grow beyond the people's wildest imagination. I'm Christine Ravold. If you liked this video, please help us share it and subscribe to our channel. Thanks for watching.